Good morning, guys. Breaking news this morning from the Supreme Court in Delaware. I know a lot of you didn't even know this was going on. I have not been providing ongoing coverage of it because it's been a slow-moving trial. There was an appeal filed by Rose Izzo back in December 2023 asking the Supreme Court of Delaware to reverse and remand the Chancery Court's decision on the AMC APE conversion. On May 8th, the court finally heard the oral arguments from both the appellant and the appellee. And I'll put a link to that in the video description if you want to listen to 30 or 40 minutes of legal arguing. But stick around when this video is done. I've summarized it for you in 3 minutes. But this morning, the court issued a final opinion on the case. It is very brief, and I'll put a link to this in the video description. The Supreme Court's decision this morning says that after careful consideration of the parties' briefs and the record below, and following oral argument, we find it evident that the judgment of the Court of Chancery, that would be Judge Zurn, should be affirmed on the basis of and for the reasons stated in the memorandum opinion and order dated August 11th, 2023. Basically, what they are saying here is that Rose Izzo's appeal to the Supreme Court of Delaware is denied. The decision of Judge Zurn is upheld. Now stick around for 3 more minutes and you can watch 30 minutes of legal arguing summarized in just 3 minutes.
Greg Varela from Bernstein, Lewis, Berger & Grossman.
Together with my partner, Ed Timlin, and colleagues Tom Carey from Septima White, and Krista Kuka from Fields Kuka and Shukra for the appellees.
Thank you very much, and I can't help but smile at looking at this council table. All right.
May it please the court, reversal and remand is critical for AMC stockholders to pursue recovery against the directors who were responsible for the disaster caused by the vote that the defendants rigged in favor of the reverse split and conversion. This case is critical not only because it corrects an injustice against the objecting AMC stockholders, but for Delaware law. Now, the plaintiffs downplayed this conflict by portraying the objecting stockholders as irrational and misunderstanding the risk to AMC from bankruptcy. The objectors correctly understood that the settlement and the transaction could inflict a near total loss that was tantamount to bankruptcy. And the case for reversal rests upon 3 arguments: the need for a settlement with an opt-out, the adequacy of representation, and the scope of review.
But would you agree that whether or not there is an opt-out, that opt-out rights in this situation are not mandatory, that what you're really contending here on appeal is that the trial court abused its discretion in not granting an opt-out right?
If it's not mandatory, it is as close to mandatory as can be, and it was certainly an abuse of discretion.
So I'm still unclear. So is it a due process issue or is it a discretion issue?
It's a due process issue, Your Honor, because you have a problem with adequacy of representation.
Your Honors, this appeal is unusual. Appellant is not challenging the substantive fairness of the settlement, which was approved after extremely extensive proceedings, including the appointment of a special master, a respected special master, to review thousands of crowdsourced objections, which led to the issuance of an 87-page thoughtful opinion by the special master recommending rejection of those objections. 2 days of live hearings at which objectors appeared and had the opportunity to and did testify before the court. Rather than attacking the substance of the settlement, appellant attacks the trial court's ruling on the 3 technical bases you've heard about. In her brief, objector argues that a post-conversion opt-out settlement was feasible, quote, and is today, close quote. That's reply brief at 20. But objector offers no guidance as to how such a post-conversion opt-out would work in practice.
Anyone who opts out will probably have to give their shares back. I'm sorry, Your Honor, you look kind of...
No, I'm just the wheels are turning, sorry.
No, that's fine. I'm trying to get the wheels to turn. Your Honor, unless you have any further questions, I can rest on the papers.
Thank you very much, counsel. We appreciate the arguments. We'll take the matter under advisement.
Let me know down below, what did you think of counsel's arguments and what do you think of this decision from the Supreme Court in Delaware today upholding Judge Zurn's decision? I am Tony Denaro and I will see ya on the next video.